On the 27th of May 2016, Walanga Muru, the Office of Indigenous Strategy, in conjunction with the Macquarie Law School and the Macquarie University Indigenous Student Association, hosted a forum to discuss constitutional reform. The event was attended by academic and professional staff, students and community members. It provided a chance for people to hear various points of view on the issue and a chance to ask questions. There was a lot of animated discussion, particularly around Section 5126, which is commonly referred to as the race power. Written in 1901, this section reads, after the 1967 referendum, the phrase "other than the Aboriginal race in any state" was removed.
Referendums are yes-no questions, you're right. It's not clear whether everything will be bundled up into one question. The Referendum Council is going to hammer that out after the election to the end of the year. And it might be one or it might be two separate questions. The Constitution cannot solve all our problems, but it needs to be fixed. It is both practical and symbolic that it needs to be fixed.
Yeah, I mean, this is where the whole referendum process is misleading. So they are not addressing racial discrimination. In fact, if you amend 5126, what happens is the Racial Discrimination Act is partially powered up by 5126. So you're going to unpower the Racial Discrimination Act.
And that question, that referendum question, as soon as they formulate the question and make the announcement, they're obligated to also fund the No campaign.
You know, it's a British law precedence that we have to give consent. So if 90% of our mob do not want to go through this process, and that the buck stops there, we actually want to engage into a sovereign treaty process, which is the majority of our people, I would estimate at that 90%.
That is a really good question about when does it get to the point where we know that there's enough support to make this happen. There is a very strong sentiment that failure is not an option. Where we are in this conversation is that the Commonwealth knew that most Australians don't even know about Constitution. Part of what our challenge is we need to get Australia's consciousness warmed up to the idea, first there is a Constitution.
Law precedence is to get informed consent of the natives and to get permission, and we're not permitting to allow jurisdiction at the cost of our sovereignty, and so we cannot afford to hand over the discernment of what's better for our people to a government that have already done so much destruction to our human rights.
Nobody in the echelons of law, anyway, now recognises this constitution as British. But if you simply take it out, you invalidate any statutes that have been enacted in reliance on the race power. It's because of this racism in the Constitution that I would think constitutional reform is necessary.
It's irrefutable that blackfellas never gave up sovereignty. The challenge is, how do we negotiate us being able to exercise that? So it's not so much whether is sovereignty an issue or not. Sovereignty is always there because it was never given up.
If Section 5126, the race power, is repealed, then any statute that was enacted in reliance on the race power would immediately become invalid.
Why is
unless
that so?
It can be supported by some other power. But the particular ones I've referred to, the Native Title Act and the Aboriginal Torres Strait Islander Heritage Act, probably could not be. There's a very big risk that we could lose those two acts.